Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And over here you can find previous year solved question papers of several states, year wise and subject wise as well. And from today's video onwards, we are going to discuss the exam papers of AIB All India Bar Examination, which is the mandatory requirement for an advocate to pass in order to practice in the court. तो अगर आप एडवोकेट हैं, आपको प्रैक्टिस करनी है, ऑब्वियसली आपको सर्टिफिकेट ऑफ प्रैक्टिस लेना पड़ता है आफ्टर टेकिंग दी डिग्री एंड रजिस्ट्रेशन विद बार काउंसिल। देखिए AIB एग्ज़ाम पेपर जो है 2011 में स्टार्ट किया गया था और 2011 में फर्स्ट एग्ज़ाम पेपर हुआ था इसका, एंड अभी तक 17 एग्ज़ाम पेपर इसके हो चुके हैं और अभी जो रिसेंट वाला हुआ था वो हुआ था AIB 17। तो आज हम इसको डिस्कस करेंगे। On this channel, I am going to discuss the AIB exam papers in Hindi as well as in English, because every advocate in this country, whether he is from Jammu Kashmir or from Tamil Nadu or Kerala or from Gujarat or northeastern state, every advocate has to give this exam who is taking degree nowadays. And many places it has been seen that many people do not understand the Hindi. So first we will discuss in English and then later on we will do it in Hindi as well. जो हिंदी वाले कैंडिडेट्स हैं वो निराश ना हो, हम हिंदी में भी इसको डिस्कस करेंगे, अच्छे से करेंगे। सो फ्रेंड्स, आगे बढ़ने से पहले आई वुड से कि ये चैनल आपके लिए बड़ा ही बेनिफिशियल रहेगा। दिस चैनल विल बी वेरी बेनिफिशियल फॉर यू, आपके लिए बड़ा ही बेनिफिशियल रहेगा। एंड अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, एंड डोंट फॉरगेट टू सब्सक्राइब दी चैनल, एंड व्हाइल सब्सक्राइबिंग डोंट फॉरगेट टू प्रेस दी बेल आइकॉन सो दैट यू कैन गेट नोटिफिकेशन ऑफ आवर अपकमिंग वीडियोज। एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं। मिनिमम इज 40 रुपीज़ एंड मैक्सिमम इज रुपीज़ 10,000. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. सो लेट्स मूव टू द क्वेश्चन पेपर. So you can see this is AIB 17 code A. Candidate has to fill his name here, roll number, enrollment number. And these are instructions, 1 mark each, 3 hour, no negative marking. I have downloaded this paper online, you can just find it over there. And if you do not find, just look at our Telegram channel, you can get it over there. And online several websites has given the paper, and some websites are giving the paper that typed and not the original paper like this. So it is advisable to do paper like this where you can just find a proper format and a type one which is available on other websites, and the answer key of that is totally mismatched. The set C is available which is typed, not this proper paper. This is series A and answer key of code A is right, however the answer key of set C is totally incorrect. So let's move to the question number 1. The title of the Constitution of India is laid down in Article 393. D is the answer. Article 1 is name and territory of union. Article 5 is related to citizenship, and Article 390 has been deleted. Question number 2 is constitutional provision of fundamental rights are given under which part of the Constitution of India? That is in part 3. C is the answer. Part 1 is union and its territory. Part 2 is citizenship. Part 3 fundamental right, and part 4 is DPSP. C is the answer. Next is 3. By which of the following amendment of 1985 anti-defection law was added in the Constitution of India? So it was 52nd constitutional amendment. B is the answer. And 10th schedule was added in Constitution by this amendment. Next is 4. In which of the following cases the Supreme Court decided that a constitutional amendment is a law within the meaning of Article 13(2) and therefore it violates any of the fundamental right, it may be declared void? Which case was this? This was Golaknath versus State of Punjab. D is the answer. So D is the answer. Next is 5. Uniform Civil Code in India is a DPSP. It is provided under Article 44. B is the answer. Next is 6. As per Article 16, no student shall on the ground only of, देखिए ये है रीजन, रेस, कास्ट, सेक्स, डिसेंट, प्लेस ऑफ बर्थ, रेजिडेंस, इसका आप कैसे बना लीजिए RRC SDPR। तो ये आपको याद रहेगा RRC, ठीक है ना, लास्ट में आर है तो आर से स्टार्टिंग है और आर पे ख़त्म है, तो इस तरीके से आप एक सीक्वेंस बना लेंगे. सो इट स्टार्ट्स विद आर एंड ends with R. So you can make a sequence like this. So you can remember it in the exam paper so that you will not confuse between residence and age. So it is residence only. So A is the answer. Next is 7. The minimum number of judges who are to sit for the purpose of deciding any case involving substantial question of law as to the interpretation of the Constitution or for the purpose of hearing any reference under Article 143 shall be. This is 5. D is the answer. And where this is mentioned? This is mentioned in Article 145, Rules of Court, etc. Next is 8. According to the Article 300A of the Constitution of India, no dash shall be deprived of his property to save by authority of law. No person. A is the answer. Next is 9. Which of the following is not law according to Article 13 of Indian Constitution? So rules, bylaws, custom usage, none of these. So these all are laws. So D is the answer. And where it is mentioned? It is mentioned in Article 13(2), Clause A. Next is 10. Which of the following schedules deal with union list, state list, and concurrent list in the Constitution of India? And so where the lists are mentioned, it is mentioned in Schedule 7. A is the answer. What is in Schedule 10? Defection laws. Okay. Schedule 11 is for Panchayat. Schedule 12 is for municipality. Next is 11. Under Section 82-83 of Indian Penal Code, an offence is punishable if it is done by a child of below of 7 years of age. No, it is duly incapax mentioned in Section 82. It is not punishable. They are asking about punishable, so it should be between of above age of 7 years but below the age of 12 years, having attained sufficient majority of understanding. B is the answer. No 10, below 12, not having. Wrong हो गए. This is wrong. So B would be the answer. This is 12. Name two essential conditions of penal liability: guilty intent and wrongful act. So guilty mind and wrongful act, mens rea and actus reus. C is the answer. Next 13. Provisions for right of private defense is given between Section 96 to 106. B is the answer. Next 14. The consent is not a valid consent under Section 90 of IPC if given under fear of injury or misconception of facts by a person of unsound mind या below age of 12 years. All of these. D is the answer. Next is 15. Causing of death of child in the mother's womb is not homicidal as provided under explanation 3 to Section 299. B is the answer. Next 16. Punishment for defamation under IPC is simple imprisonment for a term which may extend to 2 years or with fine or with both. A is the answer. Next 17. Assault or criminal force to woman with intent to outrage her modesty under IPC. Which kind of offense? It is cognizable and non-bailable offense. C is the answer. And this is Section 354 IPC. And this is mentioned in Schedule 1 of CRPC in classification of offences. Next is 18. A places men with firearms at the outlet of a building and tells Z that they will fire at Z if Z attempt to leave the building. A is guilty of wrongful confinement. A is the answer. Where wrongful confinement is mentioned, it is in Section 340, wrongful assistant 339. And this is illustration in Section 340. Illustration B. A is the answer. This is 19. The provision of plea bargaining under Chapter 21A of CRPC are not applicable if the offence is committed against a child below the age of 14 years. B is the answer. The chapter of plea bargaining was inserted by the Amendment Act of 2006. And sections are from 265A to 265L. Next is 20. Section 125 CRPC is secular in character. Was observed in which of the following case? It was observed in Muhammad Ahmed Khan versus Shabano Begum. C is the answer. It was said that it is religion neutral and not favors any particular religion. Next 21. Who has the power of summary trial of a case? So any CGM can summary trial, yes. Metropolitan Magistrate, yes. Any magistrate of first class specifically empowered by High Court, yes. All these are mentioned in section 260. Answer is all of the above. D is the answer. 260 CRPC. Next 22. Which section deals with process to compel appearance under CRPC? That is mentioned from section 61 to 90. A is the answer. So all that summons and warrants are mentioned here. Next 23. An offense for which a police officer may arrest a person without a warrant is known as cognizable offense. B is the answer. Where it is mentioned? It is mentioned in section 2C of CRPC in definitions. Non-cognizable offense is mentioned where? It is mentioned in section 2L and bailable offense 2A. B is the answer. Next 24. In a summary trial case instituted on complaint wherein the summons has been issued to the accused, the non-appearance or death of the complainant shall entail acquittal of the accused. B is the answer. It is mentioned in section 256 CRPC. Next 25. Suppose FIR is not registered by station house officer, okay, SHO. What are the options that the complainant has? Approach the superintendent of police या फिर approach the magistrate by filing private complaint. The first remedy is to approach the superintendent of police by writing a letter, writing a complaint and send it by post. It is mentioned in section 154 itself. And then if he is also not listening, then private complaint under section 156(3) of CRPC. So answer is both A and B. D is the answer. Next 26. Any police officer making an investigation under section 160 CRPC cannot require the attendance of a male at the place other than the place of his residence who is below the age of 15 years and above the age of 65 years. C is the answer. Next 27. If someone lies before the court on affidavit, how it can be tackled by the advocates? Perjury application can be filed. Obviously, what is perjury? Giving false evidence. And it is mentioned in section 191, 192 of IPC. Next 28. Proclamation for person absconding shall be published as follow. This is mentioned in section 82 CRPC. What is mentioned there? It shall be publicly read in some conspicuous place of the town, village in which such person ordinarily resides. This is correct. It shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides, or to some conspicuous place of such town or village. This is also correct. A copy thereof shall be affixed to some conspicuous part of the courthouse. This is also correct. The court may also, if think fit, direct a copy of the proclamation to be published in daily newspaper circulating in the place in which such person ordinarily resides. This is also correct. So all these are mentioned in subsection 2, clause A, B, C, D. So all are correct. D is the answer. Next 29. Which order of CPC deals with temporary injunction and interlocutory injunctions? That is order 39. B is the answer. What is 38? Order 38 is arrest and attachment before judgment. Okay. Order 40 is appointment of receiver. 41 is appeal. B is the answer. Next 30. A is a tradesman in Ahmedabad. B carries on business in Delhi. B by his agent in Ahmedabad buy goods of A and request A to deliver them to the Western Roadways Transport Company. A delivers the goods accordingly in Ahmedabad. A may sue B for the price of goods in Ahmedabad or in Delhi, either in Ahmedabad or Delhi. C is the answer. Where the cause of action arises or where defendant resides. The jurisdiction is mentioned in section 16 of CPC. Next 31. Which of the following section of CPC deals with the concept of res judicata? Obviously section 11, what is in 10? Res sub judice. Okay. Section 12 is bar to further suit, and 13 is about foreign judgments. Next 32, Mr. X, Mr. Y, Mr. Z are jointly and severally liable for rupees 10,000 under a decree obtained by Mr. A. Mr. Y obtains decree of 1,000 against Mr. A singly, applies for the execution of the court in which the joint decree is being executed. Which of the following option is correct for Mr. A? Mr. A may treat his joint decree as a cross decree under Order 21, Rule 18. Yeah, this is totally correct. So A is the answer. And this is illustration in Rule 18. Next 33, ABC are the co-partners of Hindu joint family. They jointly execute a mortgage in favor of Y. Y files a suit against all of them. Someone is served to C but not to A and B. None of them appears. An ex parte decree is passed against all. A and B apply to set aside the ex parte decree. The decree will be set aside against A, B and C. All of them. C is the answer. Because it is mentioned that ex parte decree is passed against all. So it shall be set aside against all. C is the answer. And where is the provision for setting aside the ex parte decree? Order 9, Rule 13. Next 34, which of the following provision of CPC deals with institution of suits? That is section 26. C is the answer. Next 35, defendant shall within dash days from the date of service of summons on him present a written statement of his defense. Order 8 mentioned here. Order 8 Rule 1 में mention किया गया ये. This is mentioned in Order 8 Rule 1. 30 days. B is the answer. Maximum days is 90. B is the answer. Next 36, which of the following statement is incorrect? First appeal can be on question of fact or law or both. This is correct. Second appeal on the substantial question of law only. Yes. Second appeal can be on the fact of law or both. No. This is wrong. First appeal may not be in the High Court. Second appeal has to be in the High Court. No. Yeah, this is correct. So C is the answer. C is incorrect. This is mentioned in section 100. Next 37, as per Order 6, pleading shall mean plain and written statement both. C is the answer. It is mentioned in Rule 1 itself in Order 6. Next 38, which of the following order deals with death, marriage and insolvency of parties? This is Order 22. C is the answer. Order 21 is execution. Order 20 is judgment and decree. Order 23 is withdrawal or consent decrees. Next 39, the doctrine of res gestae has been discussed in which section of Evidence Act? It is section 6. B is the answer. Next is 40, when the liability of a person who is one of the parties to the suit depends on the liability of a stranger to the suit, then an admission by a stranger in respect of his liability shall be an admission on the part of that person who is a party to the suit. It has been provided in which section of the Indian Evidence Act? This is section 19. C is the answer. Next 41, judicial evidence means evidence received by a court in proof or disproof of facts. Obviously A is the answer. Next 42, which of the following is not a document according to Indian Evidence Act? So definition of document is mentioned in section 3, interpretations in Evidence Act. So an inscription on a plate, on a metal plate or stone, this is a document. Map or plan, yes. Caricature, yes. So answer is D, none of the above. Next 43, presumption as to dowry death is given under which section? 113B. A is the answer. 113A is for presumption as to abatement to suicide by a married woman. Okay. 114A, no consent in rape cases. Presumption as to no consent in rape cases. Next 44, which of the following is not a secondary evidence as per section 63 of Indian Evidence Act 1872? So copies made from the original by mechanical process which in themselves ensure the accuracy of the copy, and copies compared with such copies. This is secondary evidence. Copy is made from or compared with the original. This is oral account of contents of document given by some person who has himself seen it. This is secondary evidence. Copy is not certified under 63. This is not. D is the answer. Next 45. A leading question may be asked in cross-examination. C is the answer. Where it is mentioned? It is mentioned in section 143 of Evidence Act. And about examination in chief, cross-examination and re-examination, it is mentioned in section 137. And order of these examinations is mentioned in section 138. And what is leading question? It is mentioned in section 141 Evidence Act. I see 46. Extrajudicial confession means confession made either to police or person other than judges and magistrates, or made to magistrate या फिर before judges. No, it should not be written over here. However, you can say it is an extrajudicial confession. Relevancy or admissibility can be seen later on. So A can be the answer. Next 47. The arbitral tribunal shall not be bound by CPC, Evidence Act, CRPC, both CPC or Evidence Act. D is the answer in the determination of rules of procedure. D is the answer. Next 48. Which of the following section deals with arbitration agreement in Arbitration Conciliation Act? It is section 7. B is the answer. 6 is administrative assistance. And 8 is power to refer parties to arbitration. 9 is interim measures. Next 49. Under what circumstances the arbitral proceedings can be terminated? On final arbitral award, yes. Interim award, no. Where the arbitral tribunal issues an order for the termination. So 1 and 3 are correct. So A is the answer. And where this is mentioned, it is mentioned in section 30, settlement. Next 50. Under section 29 of Arbitration and Conciliation Act, arbitral proceedings with more than one arbitrator, any decision on an arbitral tribunal shall be made by majority of its members. Obviously D is the answer. Section is already mentioned here, 29. Next 51. The provision for maintenance penalty in Hindu Marriage Act is given in section 24. C is the answer. Next 52. A Muslim wife may sue for divorce under the Dissolution of Muslim Marriage Act 1939 in section 2 if the husband has been insane for a period of 2 years. B is the answer. See, there are 9 grounds are mentioned in section 2 and this is clause 6. So B is the answer. Next 53. Muslim woman has option to be governed by the provision of section 125 to 128 of CRPC. Which section of Muslim Women Protection of Right on Divorce Act 1986 deals with it? This is section 5. A is the answer. Next 54. Which of the following is not a ground of void marriage under section 11 of Hindu Marriage Act? Bigamy, this is void. Spindle relationship, void. Decrease in prohibited relationship, void. Child marriage is valid but punishable. So D is the answer. And punishment is mentioned where? In section 18. Punishment for bigamy in section 17. Next 55. Spindle relationship means 3 generations of mother and 5 generations of father. So B is the answer. Next 56. Which one of the following is not a ground of divorce in Hindu Marriage Act? Mental disorder is here, yes. Venereal disease, incommunicable form, yes. Incurable unsound mind, yes. Live separately for less than 3 months, no. This is not. So D is the answer. So grounds of divorce is mentioned in section 13 of Hindu Marriage Act. Next 57. Indian Christian can obtain divorce under which of the following enactment? Under Indian Divorce Act. C is the answer. Next 58. Section 12 of Hindu Maintenance and Adoption Act 1956 deals with effects of adoption. B is the answer. Right of adoptive parent to dispose of their property is mentioned in section 13. Presumption as to document relating to adoption. This is section 16. Cancellation of adoption cannot happen. So this is no section in the act. So B is the answer. Next 59. Which of the following categories of case will not be entertained as public interest litigation? On family pension, PL can be filed. Neglected children, yes. Petition for riot victims, yes. Landlord tenant matters, no. These are private matters. No PL can be filed on that. D is the answer. Next 60. Who is known as father of public interest litigation in India? It is P.N. Bhagwati. D is the answer. Next 61. Which of the following is not a real purpose of public interest litigation? So vindication of the rule of law, it is a purpose. Facilitate effective access to justice, yes. Meaningful realization of fundamental right, yes. Getting famous and making wealth, no. D is the answer. Next 62. In Husnaira Khatun versus State of Bihar, right to speedy justice emerged as basic fundamental right. A is the answer. Next 63. Which of the following writ can be issued against assertion of public office? Writ of quo warranto. What is your authority? C is the answer. Next 64. Ridge versus Baldwin's case deals with natural justice. B is the answer. Next 65. Meaning of audio alterum partem. A person cannot be condemned without being heard. A reasonable opportunity of being heard shall be given to each party. A is the answer. Next 66. Rule made by Bar Council of India in exercising its rule-making power under the Advocates Act. But which one? 1961. C is the answer. Next 67. An advocate may, while practicing, take up teaching of law in any educational institution which is affiliated to a university, so long as the hours during which he is so engaged in the teaching of law does not exceed 3 hours in a day. B is the answer. Next 68. In which of the following landmark case the advocate was held guilty of professional misconduct as he has forged the court order? It was Pratap Narayan versus VP Raheja. A is the answer. Next 69. If any advocate is aggrieved by an order of disciplinary committee of State Bar Council made under Section 35 of Advocate Act, or Advocate General of the state may prefer and appeal to Bar Council of India within 60 days from the date of communication of order. C is the answer. This is provided in Section 37 of Advocates Act. Next 70. ABC Private Limited Company choose to convert itself into public company. It can do so by altering its memorandum of association and article of association by passing a special resolution. B is the answer. Next is 71. Doctrine of lifting off or piercing the corporate veil is associated with company law. B is the answer. केस आता ना इसमें Solomon versus Solomon. Next 72. Under which section of Environment Protection Act 1986 an appeal to National Green Tribunal Act lies? That is Section 5A. B is the answer. Next 73. Which one of the following fundamental duties relates to environmental protection? It is 51A. G. B is the answer. Next 74. Mr. A, who was aggrieved by an order made by controller or an adjudicating officer, made an appeal to Cyber Appellate Tribunal. Later, Mr. A, aggrieved by an order of Cyber Appellate Tribunal, may prefer an appeal to only in High Court. C is the answer. And this is Section 62 of IT Act, and they can appeal within 60 days from the date of order of Cyber Appellate Tribunal. But now that cyber word has been omitted by the 2017 amendment, but they are still asking this question in 2023. Next 75. Mr. X, a person who is intended by Mr. Y, an originator, to receive the electronic record, is under the IT Act known as addressee. C is the answer. And where is the definition in Section 2B of IT Act? C is the answer. Next 76. The minimum number of members required for registration of a trade union is 7. D is the answer. And where it is mentioned? It is mentioned in Section 4 of Trade Union Act 1926. Next is 77. The text of certified standing order shall be prominently posted by the employer in dash and in the language understood by the majority of his workmen. English language and in the language understood by the majority of his workmen. B is the answer. And where this is mentioned, it is mentioned in section 9 of Industrial Employment Standing Orders Act 1946. Next, 78. A person who has ultimate control over the affairs of the factory under Factories Act is called as occupier. A is the answer. And where this is mentioned, it is mentioned in section 2N of Factories Act. Next, 79. If the factory employs more than 1,000 workers, they should appoint qualified safety officer. A is the answer. And this is section 40B of Factories Act. Next is 80. Suppose road accident occurs, then being an advocate, what is the correct way of approaching the situation? So you will file the FIR first, obviously, for petition, then summon to insurance company, obviously. So this A is the correct way. A is the answer. Next, 81. The principle of ubi just ibi remedium was recognized in. What it means? This is a legal maxim. It means where there is right, there is remedy. And it was recognized in Aibe versus White. C is the answer. Next, 82. Gloucester Grammar School case is a landmark case based on which of the following maxim? It is on damnum sine injuria. A is the answer. Means damages, sine means without, injuria means injury, and injuria sine damnum means injury without damages. Alright. Next, 83. The National Consumer Dispute Redressal Commission under the Consumer Protection Act 2019 shall have the jurisdiction to complaint where the value of the goods or services paid as considered exceeds 10 crore rupees. B is the answer. And this is mentioned in section 58, jurisdiction of National Consumer Commission. Next is 84. Under section 41 of Consumer Protection Act 2019, an appeal from the order of district commission lies to state commission. Obviously, A is the answer. Section is already mentioned. Next, 85. For an individual to be deemed to be resident in India in any previous year, one of the condition is if he is in India for a period of 182 days or more during the previous year. A is the answer. It is mentioned in section 6 of Income Tax Act. Next, 86. Mr. Kapoor purchased a residential house in January 2021 for rupees 80 lakh. He sold the house in April for rupees 94 lakh. In this case, the gain of 14 lakh arising on the account of sale of residential house will be charged to tax under which of the following head? Under capital gains. A is the answer. Next, 87. Mr. Manjot is trader supplying goods for his Singh Traders. The office of the firm is located in Delhi, whereas its godown are located in the state of UP, Punjab, Jammu Kashmir respectively. Master Singh Traders made the following intra-state supplies from different states during the current financial year. So Delhi taxable supplies 21 lakh, Punjab exempted supplies 6 lakh, UP taxable and exempted 3 lakh, and JNK 8 lakh, 3 lakh respectively. So a certain states in which Mr. Manjot is required to take registration under GST. So in Punjab it is exempted supplies and overall business is more than rupees 20 lakh. So in Delhi, UP and JNK. So B is the answer. Next, 88. The primary GST slab for any regular taxpayer are presently pegged at 0, 5, 12, 18, 28. C is the answer. Next, 89. B. The proprietor of a newspaper publishes at A's request a libel upon C in the paper, and A agree to indemnify B against the consequences of the publication and all costs and damages of any action in respect thereof. B is sued by C and has to pay damages and also incur expenses. Decide in the light of section 224 of Indian Contract Act. A is not liable. What is 224? Non-liability of employer of agent to do criminal act. So he did a criminal act or any act against the law. So A is not liable to B upon indemnity. And this is illustration B of section 224. A is the answer. Next 90, a person whom the agent names to act for the principal in the business of agency under the express or implied authority to name is called substituted agent. B is the answer. And if it is mentioned ki act for agent, then it would be sub-agent. Next 91, A dash injunction can only be granted by a decree made at the hearing upon the merits of the suit. The defendant is thereby perpetually enjoined from the exertion of a right or from the commission of an act which could be contrary to the rights of the plaintiff. It is perpetual injunction. B is the answer. And where the perpetual injunction is mentioned in section 38 of Specific Relief Act. Next 92, according to section 5 of Specific Relief Act, a person entitled to the possession of specific immovable property may recover it in the manner provided in the CPC. B is the answer. Next 93, where the mortgagor delivers possession of the mortgage property to the mortgagee and authorizes him to retain such possession until the payment of mortgage money and to receive the rents and profit accruing from the property in lieu of interest or in payments of mortgage money. The transaction is called as usufructuary mortgage. D is the answer. The mortgage, mortgagor, mortgagee is defined in section 58A. Usufructuary mortgage is defined in 58D. Simple is mentioned in B, English in E, conditional in C, in Transfer of Property Act. Next 94, in which of the following cases it was decided that a contract with minor is void? Mohri Bibi versus Dharamdas Ghosh. It is void ab initio. C is the answer. Next 95, which of the following are correct with respect to declaratory decree under the Specific Relief Act? Section 34 of said act deals with it. Yes, बिल्कुल ठीक है ये. This is correct. It is discretionary in nature. Yes, it is totally correct. So both are correct. C is the answer. Next 96, which of the following is not a negotiable instrument defined in the Negotiable Instrument Act? So promissory note, yes. Bill of exchange, yes. Check is yes. Billing receipt, no. D is the answer. Promissory note is mentioned in section 4 of Negotiable Instrument Act, bill of exchange in 5 and check in section 6. Next 97, according to Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, appropriate government can acquire the land for which of the following purposes? For strategic purposes relating to naval, military, air force, yes. Project of water harvesting and water conservation, structure, sanitation, yes. Project affected families, yes. And project for sports, health, tourism, transportation, space program, yes. So all of the above, D is the answer, and it is mentioned where? In section 2 of this act. Next 98, specified person under the Right to Fair Compensation, Transparency in Land Acquisition and Rehabilitation and Resettlement Act 2013 means any person other than. Now the definitions in this act mentioned in section 3. Appropriate government, government company, or या फिर AOP, trust society, all of these, D is the answer. And where this is mentioned in section 46 explanation of this act. Section 99, who shall be the registrar of trademarks for the purpose of Trademarks Act? It is Controller General of Patent, Design and Trademarks. A is the answer. And this is mentioned in section 3 of Trademarks Act. Next is 100. Which one of the following is not a type of IPR? Copyright, designs, patent. Historic indication is not IPR. D is the answer. So friends, here we have discussed all the questions of 17th All India Bar Examination, which was held in February 2023. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़। सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो। थैंक यू।